Welcome to part 5 of the contracts exam course. We're going to move right along now to the next topic, and that is substantial performance. It's implied that in any contract that each party has to perform some promise. It might just be one promise, it might be multiple promises. For instance, if I make a contract to wash your car for $10, I promise to perform by washing your car. You promise to perform by paying me the $10. Issues arise when performance isn't perfect. It would be very oppressive if we had a system where even the smallest degrees away from perfection constitutes a breach. It would be very hard to meet that standard, very costly, and it would also invite people to try to find mistakes or deficiencies. That way they can claim that the other party did not make perfect performance and therefore is in breach. The common law rule is that there is no breach as long as there's substantial performance. There can be damages, but you have performed on the contract. That is the difference here. I mean, you can call it breach in the sense that you didn't follow through with your promise, but all the parties the contract still goes on. Here's another contract. Here's a classic example. I contract to build a house for you. I use the wrong type of pipes. It was not specified in the contract. There was no reason for me to think that you needed a certain type of pipes, or let's say it was specified in the contract, but it was one of many different specifications. It was never informed to me that this was the assumption of the deal, something like that. I used the wrong type of pipes in the house, but I otherwise built you a great house. A court is not going to say, oh, you're in breach, you don't deserve a dime. That's not true. I substantially performed. I might have to pay damages resulting from the fact that I used the wrong pipes or whatever other deficiencies in my performance, but I'm going to the other party has to follow through with his promise and pay me. If I built a house and did a very shoddy job, it was terrible, it's missing a floor, it's structurally unsound, then there is no duty for the other party to perform by paying. The idea here is that it is implied that if a promisor, the person that is doing the promise, does not perform to at least a certain level, there's no reason for the promisee to perform his return promise. Like I said, if you build a house, make a couple mistakes, you have a house, that's what you wanted, pay me, and we'll deal with damages. But if I gave you a pool of cement, that's all I was able to do for you, that's not what you wanted. I never rose to the level of at least earning payment on the contract. If there is no substantial performance, then there is material breach. So substantial performance is required of a promisor, or there is material breach, which means that the promisee has no duty to perform. So think of it this way. I promise to do something for you. Until I substantially perform, you don't have to do anything in return. And if there is substantial performance, the promisee has a duty to perform, but can sue for damages from that breach. How do we determine whether or not performance is substantial, whether or not there's a material breach? We look at a couple things. The extent that the promisee received benefits an ordinary person would have expected from full performance. I think this is probably the most important one. If you look at that house example again, someone contracts somebody to build a house for them. If you're an ordinary person, what are you expecting? You're expecting a house that you can go inside. It looks like what was in the blueprints and so on and so forth. If it has the wrong pipes or small little things, measurements are off, the the extent is significant. So what is that extent of what you received? And here are just a couple other things. You could write these down and be aware of them on an essay environment. Are damages adequate to compensate the promisee? Hardship to the promisor declaring? Breach to be material? Was the breach willful? Did the person purposely breach? That's also another important one, because if often this comes down to an argument. Well, is it substantial? Isn't it? He didn't do a good job, but it still was a lot of work. Well, if it's willful, that's a sort of a trump card. And is there a chance that the promisor can cure the deficient breach? Here's sort of a good hierarchy, a good way of looking at this. Under the common law, if there's perfect performance, everything's done correctly, everybody's happy, the contract was performed, everybody has to perform, there's no breach, everything's perfect. Easy enough. We're not even in court if that happens. Or we go to court because one person thinks there was a mistake, but the judge says, no, it was perfect performance, there's no breach, everybody has to perform. If it's not perfect, but it's still substantial, there's a breach, but everybody has to perform. So you can think of it as a breach, not breach. It really doesn't. I mean, the term here is meant to say that you deserve damages, that you didn't follow through, but everybody still has to perform. We want the parties to go through with their economic exchange and activity, and we'll settle it with damages. We'd rather that happen than call the contract off. If there's no substantial performance, that's a material breach, and the promisee need not perform in return. The UCC is very similar. Well, let's go through it. It's similar in the sense that if there's perfect tender, there's no breach. But this substantial performance is missing. So it has 2 out of the 3, sort of. Let's take a look. The perfect tender rule, that's what distinguishes the UCC from common law. If there's perfect tender, there's no breach. Otherwise, there's breach with a bite. So we lose this substantial performance. I call it breach with a bite. It is really, you can think of it as material breach. But the idea is that there's still a chance that the merchant is going to accept and then sue for damages. That's totally permissible. There might be a right to cure, depending on the timing. See, it's not so oppressive that automatically all bets are off. There are a couple different ways to fix things here. So it's breach with the bite, but it really is material breach. Either perfect tender, otherwise you have your breach. So what if there is a material breach? What happens? The losing party, so the person who breached, is not entitled to contract payment or the return promise. We've said that. The contract is over, but the losing party can sue for the value of the benefit already conferred. What did they get? This is equity. What did they get? The smaller of market value or value that is as defined in the contract. An example. I say I'm going to build a house for you. I do an awful job. I don't substantially perform. But I built a nice fence around the property. And I sue for the value of that benefit that I conferred on you. I can't sue on the contract because the contract is over. But I can sue for the value of this benefit. What is it? The smaller the market value or the value in the contract. If we stated in the contract somewhere that building the fence is worth $50, but the market value is $60, I get $50 because it's the lesser. If we stated in the contract that making the fence is $70 and the market value is $60, I get the $60. You get screwed, essentially. So to summarize, material breach means there's no substantial performance. It cancels any corresponding promises. What is this? A total and material breach. Yeah, it's sort of material breach on steroids. It cancels the entire contract. We've really been talking here in terms of a promise for a promise. I'll build you a house, you pay me. But a total and material breach knocks out a contract even if there were additional promises. So in order for that to happen, there really needs to be a divisible contract. Each party's performance can be divided into autonomous parts. Here's an example. Let's take a look and read this one. Biff will wash and wax a car for $10. There's two things there, washing and waxing. Are these autonomous parts? No, it's one thing. You can't wash and then ask for a certain amount of money and then wax it. The washing and the waxing are one single conduct, paid for $10. So that is not an autonomous part. Biff will detail car A for $10, and he will then detail car B for $15. Those are two things. You do one and you get paid. You do the other and you get paid. They are autonomous parts. Now let's look at a couple possibilities. There's substantial performance if, for instance, Biff were to leave small streaks of soap on the vehicles after cleaning them. He came close, but no cigar. There were still small streaks of soap. Now remember, we're not in UCC here because this is not a good, this is a service. If it was a good, he has to either supply perfect tender or he's in breach. And effectively material breach, he has to cure that. But since this is a service and we're applying common law, it's substantial performance, and the other party can sue for whatever damages the streaks of soap cost. A material breach would be, for instance, if Biff forgot to wax car A. He doesn't get the $10. He doesn't get anything. And what if he waxed car A but did a horrible job? It was not substantial performance at all. Doesn't get the $10. Nothing. A total material breach, if Biff forgot to buy waxing formula, now he can't do anything. All bets are off. Order of performance. This specifies when the different promises have to be executed. Each party does something and there's consideration from the other party in return. So ultimately, unless it's a gift, in which case it wouldn't be a contract, there has to be something, at least one thing done by each party in return for the other. And how do we determine when that happens? Well, it might be specified by the contract itself. Bill will deliver on Tuesday, Jack will pay on Wednesday. That's fine. If it's not stated in the contract, a judge or court has to read in a gap filler and figure out what an implied order of performance. And it's usually, we look at it as conditions. Person A does something, after that happens, person B then pays. You don't pay unless you get the performance in the first place. If it can be simultaneous, then it's implied that it should be simultaneous. I have a painting, I'm going to hand it to you, you give me $10. It doesn't make sense for one party to take possession of either money or the painting before the other party got what he wanted. No one would take that risk unless you would state it in a contract. And it's staggered if it's either implied by the terms of the contract or if performance would take more time for one of the parties to substantially perform. If I contract to build a house for you for $100,000 and I start building it, imagine if you pay me that $100,000. Now I have your money. That makes it a lot more difficult. If something goes wrong, you have to wait until I either substantially perform or complete it. Because at that time, then I do deserve the money. Because for all you know, if you handed me the money on day one, I might never substantially perform, and now I have your money and you got to get it back from me. That is not implied unless it's stated by the parties. Excuse. An excuse is when a condition is removed. Well, we spoke the difference between a promise and a condition. A condition, when it occurs, then a promise, the duty to perform a promise materializes, or a condition stops a duty to perform a promise. those conditions can be removed, so to speak, or the entire contract performance itself can be excused. A party can voluntarily waive a condition to performance if he or she desires to. That's fine, that's allowed. This is not changing the ultimate promise. This is only changing a condition as to when you should do the promise. See, a contract is a legally binding promise. So the condition is really just saying when the promise should be done. That's why you don't need new consideration, generally speaking. But sometimes courts will say that if the condition was material, that there should be detrimental reliance. The fact that you're allowed to excuse conditions after the fact allows the parties some ex ante flexibility. A condition later on might make things extremely difficult. To make it easier, a party says, you know what, don't worry about that. You can go ahead and perform without that condition. That's fine. If the other party commits conduct that hinders the occurrence of a condition, he or she is penalized by having to excuse that condition. An example here would be if I hired someone and said, once I secure a permit, you have to come and build something on my property. I get the permit, then you build. What happens if I don't get the permit because I never went down to City Hall, or I lied on the application because I didn't want to get the permit anymore because I didn't want this deal to happen? That is failing to cooperate, sabotage. I violated my implied duty of good faith. I'm penalized by having that excusing that condition. Now I have to pay that person. Now, action of an outside agent. The conduct of outside forces prevent the occurrence of a condition or make its performance materially more costly. So we made a contract, and something happened due to an outside force that has changed things. Let's say I'm a guitarist. I'm hired to perform in Madison Square Garden on Friday. Madison Square Garden on Thursday burns down to the ground. A condition of my promise to perform was that there would be an arena for me to play in. And that's a material part of the bargain. We're not talking about some sort of condition where I'll play a certain song if the New York Giants were to win. Like some sort of condition affecting performance that's going to a very minor part of the performance. The idea is it has to be material, and having an arena to play in is absolutely something that's material. But the second question to ask, do the doctrines of mistake or impossibility apply? Just because something becomes more costly does not mean it will be excused necessarily. We have to look to mistake or impossibility. And why do we have these? I mean, the courts could have a rule where, anytime things after the fact became more difficult, you guys are excused. You didn't think that would happen. Fine. You're allowed to excuse. No. If you enter a contract, you can rely on security of the other person having to perform, and there is a high cost to canceling contracts. If I'm a company, I make a contract, people will invest in my company thinking that the contract will come through. I'm relying on it, I'm valuing it. We can't just willy-nilly be discharging contracts just because something due to an outside force makes it more expensive. Imagine an example, a famous example. I hire someone to ship something from Egypt to the United States. The Suez Canal is closed. The ship would now have to go all the way around Africa, making it an incredibly long journey. So that was an outside force that prevents the occurrence of a condition we normally thought, or it makes performance more costly. We thought he was going to go through the canal. Now he has to go all the way around Africa. But was the condition a material part of the bargain? Do I care where the shipping went through? Do I care that it went through this canal? No, I only care that it comes to me. And secondly, we need to reconcile it with mistake or impossibility. Because I might say, that's not my problem that the canal closed. It's still possible to deliver it to me. It's up to the shipper. He should have bought insurance, bought a faster ship. I don't know. I don't care. All I care about is whether or not it is delivered to me. And so that's why we'll turn to mistake or impossibility.